Good afternoon and welcome to Deloitte's Debrief Webcast series in Asia Pacific. Our webcast today is from our corporate income tax series and is titled European Union DAC6 Keeping Up with the Changes. My name is Klaus Schürmann and I'm a tax partner in Deloitte's Hong Kong office. I have the pleasure of hosting today's webcast here. I have one speaker with me today, Owen Gibbs, who will introduce himself shortly. You may access our bios on the left side of the screen, please. Before I introduce the agenda for today's webcast, I'd like to take a moment to highlight some of the features of our webcast console. First, all users are on listen-only mode. If you have any content-related questions, you can submit at any time in the Q&A box at the bottom right of the screen, please. We'll do our best to respond to your questions during the presentation. Second, all PC users can maximize or minimize each box at your convenience during the webcast. You may also explore the icons at the bottom of the screen. If you want to download today's slides and related publications, please go to the Downloads and Links box. On the other hand, mobile device users can view the slides and answer the survey on the screen. Thirdly, if you require attendance record for this event, you can download your CPE certificate by clicking the Request CPE icon at the bottom of the webcast console. With that, let's take a look at the agenda and let me introduce the topics. So firstly, we will recap the European Union Directive. We will give a status summary of the implementation of the directive in the various EU member states, together with penalties. And beyond EU member states, I should mention that the UK will be covered here as well, even though the UK, after Brexit, has left the EU formally. We will then move on to some practical examples and give some country perspectives on how certain cases are likely to be treated in different countries. We have made a selection of countries here, which are some of which are a little bit more strict, others are a little bit more lenient. We will then go into some process considerations and we'll finish off with Q&A. So next slide, please. With that, we would start with a polling question to keep everybody active. So the question is, have you already assessed any cross-border arrangements or transactions with Europe with regard to these new DAC6 reporting requirements? So please tick one box of the 5 options shown here. And while you submit your answers, I would ask Owen to please introduce herself.
Thanks, Klaus. Hello, everyone. My name's Owen Gibbs. I'm a partner in Deloitte UK office based in London. I've been leading a lot of our DAC6 services and the development of those services for clients over the last couple of years. As Klaus just mentioned, the UK has left the European Union. And in doing so, there's been some changes to the implementation of DAC6 locally that we're going to cover as we go through this presentation. But for today, alongside Klaus, talking through those rules and trying to share some perspectives from what we've seen in Europe around client implementation of this directive.
Perfect. Thank you, Owen. And here are some results. So we can see that 28% have already checked, 20% have checked and reported. So we are at about half of the participants. The participants are over 700 today. Half of those are aware of the regulations and have already done some steps. So I think that's good. And for the other half, it's particularly interesting now to get an introduction. So Owen, with that, I would hand it over to you for the intro.
Perfect. So hopefully we can help the 7.5% that weren't sure what DAC6 is with this first section. So we just want to recap the European Union directive that brought these rules in. So if we turn to the next slide, just to get people used to some of the jargon, starting at the top, this is the 6th version of the EU Directive on Administrative Cooperation in the field of direct taxation. So that's why it's referred to as DAC6. the Directive on Administrative Cooperation, 6th version, DAC6. You might also hear it referred to as EU MDR, and that's because these are EU rules around mandatory disclosure. So that's where the MDR comes from. If you see either of those, it is the same thing. What the rules aim to do is to provide new information on potentially harmful tax practices to authorities within the EU member states. And it does that by requiring new disclosure obligations on EU intermediaries and in some cases taxpayers in relation to anything that is classified as a reportable cross-border arrangement, or RCBA. So lots of acronyms there. We're going to go through those in a little more detail on the next slides in a second. But if we just look along the bottom of this slide, for those not familiar with how an EU directive works, the EU sets out an objective, and the directive is the legal act that forms that objective. Each member state then needs to transpose that directive into local law. So they take the wording of the directive, they might just translate that into local law, they might make changes at that point, but they are expected to broadly stick to the objective. Further down the line, the EU Commission will monitor those implementations and check that all member states have transposed the objective effectively into local law. That process of setting the objective and the transposition has largely happened, but I'll go through the status in a later slide. So if we move on to the next slide, please. This is essentially setting out the mechanism for reporting. So the objective is to obtain more information on cross-border arrangements that meet certain criteria. And reporting is primarily expected to be performed by an intermediary. So that's an EU entity which either acts as a promoter or a service provider towards an arrangement that involves tax. Now, the promoter would typically be someone like a Deloitte or a lawyer, as an example of someone who might be seen to be promoting an arrangement. A service provider would typically be a financial institution that might be involved in the financing or the structure of the arrangement, perhaps didn't design the scheme itself. And interestingly, these are very broad definitions. So the definition of a promoter intermediary could also capture in-house tax departments that provide tax advice to other areas of the business. And I've seen that a lot in the corporate space, where one tax department in a country might be advising other areas of the business on implementing arrangements. So the intermediary is not just limited to the likes of Deloitte, it goes much wider than that. The second role I just want to touch on the right of the slide is the taxpayer. Now, the taxpayer is the person that benefits from the arrangement. Typically, they will not have to report, but they might have to if the intermediary is unable or unwilling to file the report. So if there was a taxpayer with EU nexus who takes some advice on an arrangement that the intermediary, for example, sits outside of the EU, it doesn't meet the definition for a reporting intermediary, the obligation can fall back on the taxpayer. It's important to understand those roles because that does create a level of complexity in understanding who is going to fulfill any reporting obligation if it arises, even before you start assessing the thing in the middle there, the RCBA, or Reportable Cross-Border Arrangement, which is looking at the substance of the advice provided, checking whether it meets any of 5 hallmarks, and then reporting that arrangement if needed. That if an RCBA is identified, a report will need to be submitted to at least one tax authority in the EU member state impacted by the arrangement. And in certain circumstances, it could be in multiple member states. So moving on to the next slide, we just want to recap what would make something reportable. And the directive sets out these criteria it refers to as hallmarks. These are essentially 5 headings for characteristics which, if present, will cause something to be reportable. So if you have an arrangement that goes cross-border, one leg of which falling in the EU or both legs in the EU in different countries, you need to consider whether that arrangement meets one of these 5 hallmarks. The hallmarks in dark green to the left are subject to a main benefit test. So for those hallmarks to apply, the main benefit, or one of the main benefits of the arrangement, has to be obtaining a tax advantage. So there's an initial hurdle that needs to be considered before you look at either A or B or parts of C. And we'll draw that out in the examples later in the presentation. For the latter parts of C, D and E, there is no main benefit test. So even if you are not expecting to derive a tax advantage or aiming to derive a tax advantage, it wasn't one of the main reasons you went into the arrangement, it still may be reportable under DAC6 if any of those hallmarks, are present. As I say, we're going to go through some examples later, but the key hallmarks that we see consistently hitting in industry is probably B, parts of C, depending on where groups are structured, and certainly E, which involves transfer pricing. And with Brexit, as Klaus mentioned at the top of the call, especially in the UK, we've seen a lot of movement of businesses and restructuring that can be caught under hallmark E. But more of that later in the presentation. Turning to the next slide and just looking at the timeline. So we had a flurry of activity last year, partly due to COVID and partly due to jurisdictions not being ready to make the regime go live. We saw a 6-week deferral close to the proposed start date, which had been 1 July 2020. Most jurisdictions took that delay up. A 6-month delay, which came just before the deadline. So most jurisdictions took that up. Some decided to stick to the original date. Whatever the case, the long and short of it is that we are now live with this regime. So the directive came out on the 25th of June 2018 and became effective from that date. And anything between 25th of June 2018 right up until 30th of June 2020, any arrangements that meet the definitions of a reportable cross-border arrangement will be caught by these rules. And there was a one-off reporting date of 28th of February 2021 to report those arrangements. It was earlier in some jurisdictions that did the original timeline. So there it fell to be 31st of August 2020. So there's this back book that needs to be reported. There was also another period because of this 6-month deferral, which is generally referred to as the deferral period. So any arrangements that were implemented in the latter half of 2020, so from July up till the end of December, those arrangements needed to be reported by the end of January this year. So all that historical reporting, anything that happened from 2020 backwards to 2018, should have already been reported by businesses, and we should now be in the live reporting window. So that's the blue bar along the top. From the 1st of January onwards, there is essentially a real-time reporting regime where if you have a reportable cross-border arrangement, somebody needs to report that within 30 days of a trigger date. Again, we'll look at some of these terms later in the presentation. And we're getting very close now to the first exchange of information between member states. So that information has gone into the tax authorities and they will themselves exchange it between the tax authorities later in April 2021. Just to summarize, it's a directive that's been around for a while. There was a historic reporting period that is split in two and drove different reporting dates, so both have passed now. And there is now a real-time element which says businesses need to monitor for reportable cross-border arrangements and report them quickly if you enter into one or know that someone else is reporting them. So turning to the next slide and just thinking about the status of implementation. So we, Deloitte, have been tracking the status of implementation. I'm glad to say that largely we're seeing jurisdictions having released legislation and supporting guidance to help businesses interpret the legislation. There are still some jurisdictions like Spain, I believe Cyprus, who are lagging behind slightly. But even there, I think there is enough for businesses to understand what the obligations should be and what should be reported. Key thing to call out on this map is the UK there in its own shade. So the UK, after its exit from the EU, surprised us all and announced that it would be dropping DAC6 and not implementing it. Instead, they are implementing the OECD version of the mandatory disclosure rules, which is essentially just Hallmark D, so relating to FATCA CRS reporting and beneficial ownership. So quite a change. I'll talk about how that plays out as we go through the presentation. Interestingly, on the right there, you'll see lots of stars. These are points of difference that we have seen arise in different jurisdictions. So I mentioned that an EU directive sets the objective and then is transposed into local law. We have seen points of variation between jurisdictions as that transposition has taken place. And I'm going to go through some of those in a little more detail. If we turn to the next slide, this initially picks up on the point I've covered there, that the UK has confirmed it will only implement Hallmark D, and that is effective immediately. But we do also see variations in interpretation of the guidance. So an example here will be Hallmark C1B1, and Hallmark C1B1 is around using jurisdictions which have almost zero tax. So a jurisdiction which has no tax could potentially cause a reporting obligation if one leg is in the EU and the other leg is in that jurisdiction. And here we can see that Germany interprets almost zero as equal to or under 4%. Poland says lower than 5%, whereas the majority or more jurisdictions have gone that it means under 1%. And the UK brought that in when it was implementing the rules, and we've seen it pop up in other jurisdictions such as Netherlands, Belgium, and Spain. So just a small illustration of how, even though the directive is consistent in its views, local implementation can introduce difficulty, and we'll cover how that impacts businesses in a practical sense further along in the presentation. We also saw a softening of the intermediary definition in Italy and Germany. I mentioned the breadth of who can be an intermediary earlier. Italy and Germany have both looked at watering down the definition of the service provider intermediary, try and exclude some financial institutions from being dragged into reporting, because there was some strong lobbying, and I think fair lobbying, which suggested those institutions like banks, for example, would not know that a loan they were providing was part of a certain structure, nor would they be expected to know, so perhaps they weren't best placed to be involved. So we see playing around with the definition of intermediary. On the next slide, I wanted to just pick up on the taxes covered. This is a real point of worry for some organisations, especially if you're in Poland. I'm going to talk about penalties in a second. It might illustrate why Poland is such a worry to many. But Poland included lots of extra elements when they implemented DAC6. So there was no expectation that VAT, or goods and services tax, would be in scope for DAC6 reporting. Poland thought it should be. Similarly with excise duty, they brought that in. They also have an extraterritorial view, so there can be Polish reporting even if you have no actual physical presence within Poland. You can trigger a Polish reporting obligation. So of all the jurisdictions, we look at Poland as a real outlier and perhaps the most rigorous implementation of DAC6, because they've actually gone beyond it. But it's a good illustration of how far some jurisdictions could take these rules. On the less extreme, Germany and Austria both included real estate transfer tax, where that wouldn't normally have been part of the directive. And also, if we look at Austria again, they took a view that if you're doing the main benefit test, which I talked about in the context of hallmarks, the main benefit doesn't have to necessarily arise in the EU. So if you had an EU to non-EU transaction and the benefit arose outside of the EU, most jurisdictions would not be interested in reporting. Austria have said they would. Again, quite subtle nuances, but they can have big impacts when assessing your reporting obligations. And then final slide on this section, I just want to go into the penalties for non-compliance. Now, when the directive came out, it was set out in the directive that local penalties needed to be big enough to be dissuasive for non-compliance. And some jurisdictions have interpreted that with gusto. So when we look at the likes of Belgium, Italy, and Germany, they generally have penalties in the range of €1,000 up to the €25,000 range. So not insignificant, and those can pile up if you have multiple failures, but dissuasive, but not necessarily massive fines. Then we move on to the likes of Luxembourg, and I believe the Netherlands has also gone in the mid-range. So Luxembourg has penalties up to €250,000 for non-compliance. And when we look at some of the practical problems with complying, having a penalty that large does really focus the mind in terms of making sure your business has got its compliance in order. And then finally, I foreshadowed this, but Poland has a penalty that can bite up to €10 million. So they have gone large on the penalties as well. And certainly that, again, creates an air of worry in businesses that go near Poland. But perhaps that won't be relevant for everyone on the call, thankfully. There's typically a distinction between administrative penalties and deliberate circumvention. So some of those larger penalties probably apply for deliberate circumvention more so than just an administrative failing. But again, even the administrative penalties can mount up quite quickly, even where they're in the low thousands. So worth bearing in mind that compliance with this rule is important, not least because the penalties of getting it wrong can be very expensive. And I think that brings us to our second poll question of the day, to get some audience participation. So you should see that on your screen now. And the question is, which of the following cross-border arrangements, business models, or transactions do you see in your respective companies? And you can select all that applies here. So there's the IP holding company, non-tax offshore income, tax incentives with reduced tax rates, acquisitions in Europe, finance with debt pushdown, or you're not sure or not applicable. And while we wait for those questions to come in, Klaus, perhaps you could just take us through, are you seeing any particular structures or things that you're commonly seeing in the local market that's causing concern for businesses?
Yeah, thanks, Owen. So, of course, we see quite a number of these structures that are mentioned here. I think I'm based here in Hong Kong, so what I see a lot is, of course, offshore income in Hong Kong, that maybe with regard to services or with regard to trading income. We see, of course, IP holdings or even other incentives that go beyond IP in some places in the regions. Tax incentives are quite common, although I have to say a lot of those are not necessarily newly introduced, let's say, in the last year. Of course, M&A activity was quite a bit down last year. So new structuring was a little bit down. But these structures exist for quite some years, of course. And the question then is what needs to be done with regard to existing structures. And yeah, in terms of actual reporting, so some of my clients, they are already reviewing with regard to DAC6 concretely. Reporting is starting to some extent. I guess probably reflecting roughly the awareness that we saw in the first polling question.
Yeah, and I think we can see the results now, Klaus, which probably echo what you just gone through. So the highest response, apart from not knowing or not feeling it's applicable, is seeing tax incentives with reduced tax rates. I think we're going to go through a couple of examples that draw that out. in a moment. Interesting as well, second there is the acquisitions in Europe and the IP holding company, again, probably aligned with expectations and useful for the examples we're going to go through in a moment. Slightly lower on the non-taxed offshore income point. Again, I think that's reflective of kind of what I see in the European market in terms of the areas of concern of most businesses, perhaps a slight lower focus on tax incentives and IP holding companies here, but certainly that broad split.
Yeah, then with that, let's go to the next slide, please, and into the next section, which is about the real world, practical examples with country perspectives. So next slide, please, for the first case. And you will all, I guess, recognize the cases here, which reflect some of the questions we just had in the pollings, because that's what we have been seeing. The first case would here be a debt push-down structure. We have a group holding company at the top, based somewhere in Asia, which sets up an acquisition vehicle, an SPVco, and the SPVco is acquiring a EU target. The financing is done with a debt push-down. External bank loan is coming into the acquisition vehicle, and the debt push-down is going from acquisition vehicle into EU target co. So a relatively common structure. We've seen that. Now, we think that this could fall under hallmark A3 and tested against hallmark A3, which covers substantially standardized structures. So the first question we need to ask is whether the main benefit test would be met, meaning whether the main benefit of the structure is tax related. And then the second question would be, is it a substantially standardized structure that is broadly available in the market without too much customization? Now, I would like to emphasize at the beginning that each of these structures in all your cases is subject to a case-by-case analysis, and it's not possible to just go out and say, well, we have a debt push-down structure and so it is reportable, but it needs to be really assessed in each case. So our cases here have to be considered as generic and preliminary. So we tested this generic case against 4 countries, Germany and Italy, on the slightly more, let's say, reporting side, so a bit more aggressive possibly. And both countries would probably say that the main benefit test is fulfilled. We mentioned that here with likely, again, depending on the case-by-case situation. And we would likely also say that the substantially standardized structure may be fulfilled. So likely this would be reportable with regard to Germany and Italy. So while this is probably the more aggressive countries, Owen, over to you for some other examples.
Thanks, Klaus. And the UK is still on there, even though we have removed DAC6 effectively, just because the UK guidance, I think, was actually at a good stage before the rules were dropped. It's helpful for interpretation and probably sets the tone a bit for some authorities around Europe. Now, the UK, we've put NA here because these would just not be reportable. We don't have hallmark A, but if for a second we assume the UK guidance was still in place, the areas where this might have not been reportable would be firstly looking at the main benefit test. There would be a question of whether a benefit arises. So the UK interpretation was always that a tax advantage was only an advantage if it wasn't the legislative intent. So if the structure is using a well-known, well-used piece of the legislation, even if you're getting a tax reduction, it might not necessarily be a tax advantage for the main benefit test because actually it's what was envisaged by legislation. So you're not actually getting a benefit over and above legislation. And that was quite a useful interpretive point. The other area where you might not meet the main benefit test is around whether it is a main benefit. And the UK guidance was clear that when making that assessment around whether the tax is a benefit, you could take into account other circumstantial evidence, such as whether the structure is standard industry practice, the jurisdiction you're using is one that is sort of typical for your company or company similar to yours, and that you could have this subjective consideration within the main benefit test. And we see Luxembourg as an example of a country taking a similar line. They're not exactly the same guidance, but similar ideas around the main benefit test being a slightly more difficult bar to meet. And if you don't meet the main benefit test, then hallmark A3 is not in point. The only other thing I'd throw in for both jurisdictions is whether this is even a standardized structure. So having said that they raised the bar to meet the main benefit test, they probably lowered it a little bit to say, how does something not be standardized? The expectation was that if the product needed some level of customization, and it could be quite minor customization, that it then therefore wasn't a standardized structure. I think that the thinking behind that from the UK at least was certainly like what they were looking for here were those aggressive tax schemes that get pushed out or marketed to lots of taxpayers, and essentially you're just rubber stamping the scheme between payers. It is identical. They were not necessarily looking for structures like this where you have to set up a new company, you decide where that company is located, and where you take your debt from, how you get that debt financed, etc. They felt that that was probably more custom and not a standardized structure. So, as Klaus said, absolutely comes down to the facts and circumstances. You do have to look at things on their own, essentially, and really think about it. But those are the levers that I would see in the likes of Luxembourg that businesses might conclude is not reportable.
Great, thank you, Owen. So let's move to the next slide and the next case. So here we have a restructuring into a new holdco. On the left-hand side, you see the ex-ante structure. We see a holdco 1 that has EU opco 1 with a subsidiary of EU opco 2. And the restructuring is taking place. You see that on the right half, ex post, in order to create a more tax-efficient cash repatriation and to reduce, for example, withholding taxes. Whether or not that is the main benefit would have to be determined. Now, again, we tested against hallmark A3, and you may regard it as repetitive, but we chose the structures here a little bit according to what, in terms of practical cases, we see as relevant. So again, here we would test against hallmark A3. So again, main benefit test is the first question we need to answer, which again, from a German and Italian perspective, we would arguably confirm and say main benefit may be tax-driven. And then we would look into substantially standardized structure. And again, from these both countries' perspective, we could arguably say, or hear the tax authorities say, that this could be standardized. And therefore, we would come probably to a reporting obligation for the first two countries. So a little bit similar to the first case, but Owen, what's in it from your perspective?
Thanks, Klaus. Yeah, so similar to the first case in terms of why we might argue it would not be reported in the likes of Luxembourg. Interestingly, and there's a question come in the chat box, which I'll pick up as we go along here. We're considering these structures under one hallmark, and it's doubtful that it would meet A3 in Luxembourg or the UK before it removed the rules, certainly not after it's removed the rules. But I think the question on the chat box was just around the main benefit test. And the question is, essentially, if there is no main benefit in either leg, does that mean that it is never reportable? Yes, under certain hallmarks. So if there's no main benefit, you would never meet hallmark A, you would never meet hallmark B, but you could meet C, parts of C, D, or E. And the point I probably call out here is just around hallmark C, and that includes where you use a jurisdiction that, for example, is on the OECD blacklist, or the person in that jurisdiction has no residence for tax purposes. Now, what that means in this example is if the main benefit test isn't met, as I argued through in the last slide, that's fine, hallmark A isn't met. But depending on where that new holdco is, it could make the structure reportable under hallmark C if there's a main benefit, all of C. If there is no main benefit, certainly parts of C, such as that entity has no tax residence, or if that jurisdiction happens to be on the OECD reportable list, as Cayman was for a time, or UAE, which are countries that are not uncommon to have holding companies in. So to answer the question, yes, if there's no main benefit test, it wholly rules out certain hallmarks, but nonetheless, you still need to consider all the hallmarks. So just because something's not reportable under A, it could be reportable under C, or possibly E in this case. Again, transfer pricing. We'll come on to an example which rules out hallmark E a bit better in a moment.
Great. Okay, then over to the next slide, please, and the next case. So here, finally, we come to a different hallmark, although still including the main benefit test. A payment to an offshore company, for example, Hong Kong. So we have here the group holdco in the middle, an EU operating company, and let's say a buying entity or trading entity in an offshore jurisdiction. And the EU operating company is making deductible payments to the offshore company. So the EU operating company would deduct for tax purposes this payment, but on the other side, on the receiving end, the offshore company does not tax the income generated. Now, we tested that against hallmark C1, and Owen, as you just rightly mentioned earlier, of course, we took a bit of a shortcut here, not testing against all the hallmarks in every case. And of course, here all the cases we checked against the most likely hallmark, and where we see differences in various EU member states. So in this case here, hallmark C1 is a potential applicable hallmark. The main benefit test may be met. We have here C1B1 mentioned earlier. So a payment that goes into a jurisdiction that imposes, say, almost zero taxes or zero taxes. Arguably, that could be the offshore company. The offshore company could as well be replaced by a preferential tax regime under certain tax incentives, and therefore main benefits test might be met, and the countries Germany and Italy would likely also consider this as a reportable transaction, considering no tax pickup in the offshore jurisdiction. Owen, what about?
Thanks. And this one I felt was much more close to the line. So whilst we've still said it wouldn't necessarily be reportable in somewhere like Luxembourg or anyone following close to the Luxembourg or UK examples in terms of guidance, this one is, I think, bearing closer analysis. So on the main benefit test point, same points as before. you have those arguments to suggest why tax is not a main benefit of this arrangement. So you might get out and not have to look at those hallmarks. But if you do, I think there's some guidance around what almost zero looks like. And we saw earlier that different jurisdictions have different views on that. And certainly some have set that below 1%. So it doesn't take much for that hallmark not to be met. Full tax exemption, you'd have to look at the facts and circumstance. Preferential tax regime, I think within certain guidances, that definition is quite narrow and looks at existing EU lists of what are considered harmful tax regimes, which in itself limits the scope. So it's not just any regime that's preferential, it's one that's been deemed harmful. But those are lots of reasons why those hallmarks may or may not be met. But as I say, this one is closer to being reportable for me. The difficulty on the no main benefit test. So even if you ignore the main benefit test, C1A or C1B2 could be met if that happens to be a non-cooperative jurisdiction. Not too many of those about at the moment. Actually talk about that list, which recently had Barbados removed and Dominica added. So the list of non-cooperative jurisdictions is quite narrow at the moment. Previously, I said it did have some big jurisdictions on it, structuring like Cayman, like UAE. The one I really wanted to pick on here is no tax residence. And in the context of Hong Kong, there was a problem in the initial drafting where territorial tax regimes caused a big issue, because you could read it that anywhere with a territorial regime essentially meant that any companies located there did not have tax residence. That's been corrected by most jurisdictions, so would be an argument for why this wouldn't be reportable as having no tax residence. But again, it needs some close consideration, this example. And I do see these types of arrangements as the most problematic for pretty standard corporate groups, because depending on where you're located, you can quite quickly have to do some very nuanced analysis to decide if an arrangement is reportable.
Thank you. And over to the last case, please. Next slide. So here we look into IP and license payments. We have a group holding company again, similar to the picture before, with a EU operating company that pays license fees to an IP company. The IP company may, as in the title mentioned, be a Chinese high-tech status. It may be a Cayman IP company, or under IP incentives in other jurisdictions. The license fee for operating company would be a tax-deductible payment. So we would look again through the main benefit test, make some assessment whether or not the main benefit test may be met. Based on the discussion that Owen had earlier, main benefit versus no main benefit test. I don't think we need to repeat that here. An additional point here may be the review of the preferential tax regime, which in some countries may be applicable. Again, as mentioned here, Chinese high-tech status. So from a generic perspective, we see here, again, good chances that countries like Germany and Italy may consider the main benefit test to be fulfilled, leading to a potentially reportable cross-border transaction if the case is sufficiently, let's say, structured. But Owen, I think again, you have some points to make, and even beyond hallmark C1.
Yes, and I think that's where to focus, because, yeah, for the reasons previously discussed, C1 might not necessarily apply in all jurisdictions here, either because the main benefit test is not met, or because there are specific issues with the hallmarks applying, or ways that a business might argue they don't apply. The point I really wanted to pick up on is on the left of the slide, just talking about hallmark E. and reinforcing that point around the level of analysis you need to go into. Whenever we see anything involving high-tech companies, IP companies, pharmaceutical, those businesses that traditionally have intangible assets and moving around the group and IP moving around the group, we would always be on high alert for whether Hallmark E might be met. And Hallmark E, as a reminder, is the hallmark that covers elements of transfer pricing and certainly transfer of hard-to-value intangibles around groups. Hallmark E, there is no main benefit test, so it always can apply. And not necessarily in the 3 boxes in front of us. You know, that might not be case in point here, but just in the context of that type of business, I guess if I was performing an impact assessment, I'd be having a slightly deeper conversation to understand that, okay, if this structure isn't core, should we just have a discussion around how you transfer IP within your group? Because it's likely that further down the line, Hallmark E might be reportable, and you would want to understand that before it happens so you can be ready to report. So not necessarily a point around the diagram we're presenting, but more a point around the practical approach to undertaking analysis. And that's something that I'll go through in a little more detail in the next section after our next poll question.
Great. So let's move to the poll question. So we changed the topic a little bit now from the practical cases, again, more to the process and governance. So what governance or process approach are you taking in your companies, or have you taken, to addressing and complying with these rules and control these rules? So Owen, quick question while we're waiting for the results here. What do you think? Is anything similar, a similar regime like DAC6? Can that be expected in other regions of the world? Like especially here in Asia, I think we are maybe not too keen to getting that.
So the UK's decision's interesting. So the UK are not implementing DAC6, they are implementing the OECD mandatory disclosure regime, and that OECD MDR is just Hallmark E. So it's just around FATCA CRS reporting or reporting where beneficial ownership is being obscured in some way. Quite narrow reporting. That is definitely a global initiative, as most things by the OECD are. We've seen the likes of Mexico and South Africa looking at bringing out those rules, certainly the Channel Islands close to the UK. I would expect that most jurisdictions that have signed up to US FATCA or the OECD Common Reporting Standard will implement Hallmark D at some point in the future. That's my expectation. Now, hopefully not panic for people on the line, because that is unlikely to affect non-financial institutions. So if you are a financial institution under FATCA or CRS, then watch out for these rules. I suspect we will see global proliferation, but in terms of all of DAC6, all 5 hallmarks, we have not seen that to date. It does seem to be an EU measure at this point. And that's probably reflected in the answers we're seeing on the screen now, I think, Klaus, in terms of how people are looking to comply with the rules, with the majority of people looking to sit responsibility in their primary EU location, so respectful of these being EU rules requiring EU specialism. Interesting to see that people are also looking at responsibility in multiple locations, so possibly a kind of spread out approach to governance. There's some practical points we'll pick up in a moment which might challenge that slightly. And certainly responsibility with the intermediaries, the kind of reactive approach. I'm just going to go through some practical examples. Again, just that might be right for some businesses. It's not right for everyone, but just to put a slight challenge to that response. Should we move on to the next section, just in the interest of time?
Yeah. just move straight on.
Thanks, Klaus. So then we're just talking about the kind of practical challenges, and I'll go through these relatively quickly because I think we've touched on a number of the points as we've gone through the examples. The first thing we see clients really struggling with is really the limited clarity on the rules. Even though I've said that jurisdictions have released guidance, we have the legislation, this is clearly a regime that is going to evolve, and it is clearly a regime where there are differences between jurisdictions. So the directive itself almost deliberately lacked clarity on the specifics and definitions. It looked to keep the net very broad for who was caught by these rules. And there are obvious points which you can grapple with. We've just gone through an example or a number of examples that talk about the main benefit test being difficult. There's close to zero and what that means. What is a transfer under hallmark E? What is a preferential tax regime? The list kind of goes on. So I'm not going to go back over those again. I think one point mainly to call out on here is the style that businesses are taking. So there's two ends to the spectrum. We see some businesses saying we're going to report everything. They can have everything. We've got nothing to hide. We'll report everything and let the tax authorities sort it out. And then at the other end of the scale, there might be people who are analysing in detail and are very averse to reporting. Now, there's merits to both approaches, but the one thing I wanted to call out here, because I see more of this, is the attitude of report everything can be problematic. Because I think in making a report under these rules, whilst you're not saying what we're doing is wrong, you are making some statements around why you are doing things. So if you report everything, as an example, and say you report under hallmark B or A, you are essentially making a statement. Your business has gone into this because of tax, because it's inferred that the main benefit test has been met. So I just think it's important to be careful when picking your in-house style that you don't just default to thinking, well, we can report everything and that's fine because we've got nothing to hide. That is true in some sense, but also just think around what the kind of hidden signal is in the report, and that might be, for some tax authorities, not all, but for some, that you are suggesting you are quite aggressive on tax, so it might not align with your stated policy elsewhere. So I'd just say be careful of that. The other thing around analysing and reporting, Klaus said it, we've gone through a really high level in this presentation, but ultimately reporting really does come down to the specific facts and circumstance, and even the timing of an arrangement. So it might be that you're using a jurisdiction that is not on the harmful list now, but is another day. So it is a nuanced analysis. It is not the case that you can just have a list of things that are reportable, things that aren't. You need to be equipped to do the analysis or to make sure someone's doing the analysis on behalf. So moving on to the next slide, just thinking about managing multiple intermediaries. When I went through the mechanism for reporting at the top of this presentation, I was probably quite binary in how I set that out and quite simplistic. We need to acknowledge that in any given arrangement, there might be multiple intermediaries, there might be multiple taxpayers, there might be multiple jurisdictions. And the example here, I mean, we toyed with dropping the UK flag from it, given the UK has dropped the rules, but actually it illustrates a point quite nicely. So in the past, we would be talking around, naturally, if the intermediary, the designer at the top has a UK advisor and it's designing the scheme in conjunction with them, you'd probably expect the UK advisor to be the reporting intermediary. So we could put Deloitte in that diamond there, Deloitte UK. But now the UK does not have these rules. So whereas before everyone could rely on the UK reporting, and so all the advisors could know, well, this one advisor is reported, and as long as they were happy with the content of the report, they would not need to file a report. The UK is now taken out of the equation. So now you're looking at whether the German advisor is going to report or whether the Dutch advisor is going to report. Now, in Germany, professional privilege might apply to tax advisors, so they might not be willing to do the report. And also, the advisor in Netherlands might feel it doesn't have the information. It doesn't know what can be reported, so it therefore doesn't feel it's its responsibility. And suddenly you're looking at, okay, who is reporting this scheme? Is it the relevant taxpayer in Germany, relevant taxpayer in Netherlands? Who's gonna do this reporting? All the while, there's a 30-day ticking clock. So it is worth revisiting that governance point where we asked on the poll question, because the timeline once you get a reportable arrangement is so short that you can't lose any time debating how it works for your organisation. You need to understand who is responsible for making sure a report is submitted either by your organisation or by someone outside your organisation. Someone will really need to take the lead on that, and managing multiple intermediaries or indeed group entities can be really difficult. The next slide, again, just picks up on that sense of a quick timeline. So we talk about the trigger date for reporting. There are lots of different trigger dates. It's probably quite obvious when the first step is implemented, but it might not be so obvious when something is made available for implementation or when it's ready for implementation. Essentially, the 30-day window starts with the earliest of these triggers. So not going through them in detail and conscious of the time, but the slides out there for you to look at, your business will need to understand in any arrangement you enter, either as intermediary or taxpayer, who is monitoring for this trigger, when is it met, and who is going to do the reporting. It's only 30 days from that point. The final kind of problematic slide I wanted to put up on the next slide is just around understanding the reporting process in each country. This is an evolving point. So we've seen that guidance and legislation is largely out. Tax authorities themselves are struggling to keep up with the pace of change and make available the portals and the mechanisms to allow reporting. So on top of the technical challenge, tax technical challenge of how do I know if something is reportable, you also will start running into the challenge of how do I even report this if you have a reportable cross-border arrangement. So some legwork in understanding who will be doing that reporting, and if it falls back on your business or is likely to, what is that safety net to allow us to do that is important. At present, reporting is largely manual in lots of jurisdictions. It is electronic in format, but it's hard. You can't just automate reporting at this point. So acknowledging within that 30 days we just spoke about, you're going to lose a bit of time deciding how to report. It's really important. So then on to the next slide, and just to bring our presentation to a conclusion with some thoughts for how this impacts clients. There is a scale of impact, so higher impact, multinational, high tech, pharmaceutical, lots of entities tend to be higher impact. Lower impact, minimal EU presence, manufacturing, retail, not too aggressive on the tax front. So you sit somewhere on that scale. You always have to answer the questions of what needs to be reported, what will others report on you, and also importantly, what's not being reported and why, because further down the line, that could come under challenge. And the final slide in today's presentation, just moving on to the final slide, just draws that out a little bit more in terms of, well, what does this look like? What do we see clients doing on that scale? So at the lower impact level, in terms of stakeholder engagement, it's largely run out of tax departments and just interacting directly with the service provider. That might need to bring in wider internal groups if you're a higher impact organisation, such as legal entity management, compliance functions, in order to monitor compliance. In terms of managing the rules, understand that you can rely on external updates at the lower end. You're going to want to be proactively monitoring for changes and getting ahead of those changes, not waiting to be told. Upskilling and governance I'll take together around one-off training. Governance, you likely rely on external intermediaries at the lower impact, but even if you're getting to medium or high, you probably want to develop a DAC6 policy and framework and understand the process of reporting, as well as reinforce that with ongoing training for people. And finally, technology has a role to play. The most low impact can use Excel to track these and report it, but most businesses of any scale we've seen developing at least a database to understand what's being reported and applying technology to allow them to report. But those are the key parts of what our clients need.
Okay. Okay, that's unfortunately all we have time for today. I think Owen may have technical difficulties right now, so unfortunately no time for Q&As. But please send your Q&As that you may have through. Owen, thanks again, and special thanks to all of you who were able to join us. Please fill out the short survey at the end that will pop up on your screen momentarily and tell us what you think about today's program. If you joined us late, please note that the presentation will be archived for future viewing or for a repeat view from your side. If you feel that others would benefit from this webcast, please share the webcast via the share this icon or have them visit the Debriefs website. We will respond to all the questions submitted as soon as we can summarize the questions. And please don't forget to tune in to our next scheduled webcast from the Corporate Income Tax series on 25 March titled Tax Controversy in Asia Pacific, Implications and Takeaways, which is part 2 in this series. At last, from all of us at Deloitte here in Asia, as well as Owen in the UK, thanks a lot for your participation in our Debriefs series. Hope to see you soon again and have a good remaining day. Goodbye.